Among those principles is the Sixth Amendment's guarantee that the accused shall have the right to be informed of the nature and cause of the accusation against him. That right has been recognized to have special force in perjury cases, where it is the rule uniformly enforced by the courts that an indictment must inform the defendant specifically what false statement he is alleged to have made. This is not some mere technicality, it is the law. It's the law because our courts have recognized that if a criminal charge is to be based on the words uttered by a fallible human being, he must be allowed to defend the truthfulness of the specific words he used and not be convicted on the basis merely of some prosecutor's summary or interpretation. This is not some legal nicety that the House of Representatives can ignore, as it has many other elements of due process. This is not an argument we raise with this body merely in passing as a lawyer's gambit. This is an important principle of our jurisprudence, and I suggest that it is one that this body must honor. There's not a court anywhere, from highest to lowest, who would hesitate if they were confronted with an indictment written like these articles to throw it out. Indeed, if you want some evidence of how others have perceived this issue, look to the Hastings and Nixon cases, in both of which the articles charging impeachment specifically stated the false statements that they were accused of having made. Why, if the House understood the importance of specificity in those cases, did it not understand the, if anything, greater importance of telling the President of the United States what he was charged with? If you compare the closing argument of majority counsel and the majority report filed by the committee and the trial brief filed by the House and the presentation of the managers last week, you will begin to understand what has happened here. I challenge any member of the Senate, indeed any manager, to identify the charges that the House authorized them to bring. Just to take one example, we do not know to a certainty that the House decided, or we do know to a certainty that the House decided not to charge perjury in the civil deposition. Yet to listen to the manager's presentation last week, one would be hard put to conclude that they understood that. They have, in essence, treated these articles as empty vessels to be filled with some witch's brew of charges considered and abandoned, and charges never considered at all. And both Article 1 and Article 2 are constitutionally deficient for other reasons as well. In particular, each charges multiple offenses and is therefore void in the criminal justice vernacular for duplicity. Because in a criminal case, and here as well, lumping multiple offenses together in one charging document creates a risk that a verdict may be based not on a unanimous finding of guilt as to any particular charge, but instead may be composed of multiple individual judgments, and though that risk is in direct violation of the requirement of the Constitution that this body agree by a 2/3 majority before the President may be removed. Now, the House responds to the President's concerns in this regard by arguing that, the amendment of Senate Rule 23, which prohibits division of the articles, somehow addressed this concern, and that our argument would undermine the Senate's own rules. But that is not so. Rule 23 was approved to permit the most judicious and effective handling of the questions presented to the Senate. It can't be that the Senate, in passing that rule, and you know surely better than I, decided to purchase efficiency in impeachment proceedings at the price of violating the constitutional mandate to ensure a 2/3 vote for removal. Now, 3 years after the revision of Rule 23, in the trial of Judge Nixon, this very issue was presented. And Senator Cole captured that problem. Although the first and second articles of impeachment alleged that Judge Nixon had committed specific violations of the perjury statute, the third article was a catch-all, alleging that he made, quote, one or more of 14 different false statements. And I would note for you that that language, one or more, was identical to the language specifically inserted into Article 1 at the request of Congressman Rogan during the Judiciary Committee proceedings. In addressing the propriety of such a charging device, Senator Cole said, the managers should not be allowed to use a shotgun or blunderbuss. We should send a message to the House. Please do not bunch up your allegations. Charge each act of wrongdoing in a separate count. Such a change would clarify things and allow for a cleaner vote on guilt or innocence. And Senator Dole, who surely knew something about Senate rules and precedents, certainly didn't think that Rule 23 bound the result in that Nixon case. He first voted to dismiss Article 3 and then later voted to acquit Judge Nixon because it was redundant, complex, and confusing. 33 senators joined Senator Dole in voting to dismiss the article, and a total of 40 voted to acquit when it came to a judgment of guilt or innocence. Senators Cole, Biden, and Murkowski each spoke about the danger posed by this formulation. And I'll look once more to Senator Cole. This wording presents a variety of problems. First of all, it means that Judge Nixon can be convicted even if 2/3 of the Senate does not agree in which his political statements were false. The House is telling us that it's okay to convict Judge Nixon on Article 3, even if we have different visions of what he did wrong. But that's not fair to Judge Nixon, to the Senate, or to the American people. Those senators were not acting in derogation of the Senate rules or precedents. They were acting in a spirit of fairness to the accused and in the very best tradition of American due process.
President there to check in across the country on the issue of health care reform. In our snapshot